Goeiemôre, dames en here. Good morning, ladies and gentlemen. Ladies and gentlemen, I have half an hour at my disposal, so let me begin immediately. Firstly, ladies and gentlemen, let me congratulate AfriForum for organizing this event. The topic which is up for discussion here is in fact of the utmost importance. It is more specifically of the utmost political importance. It might sound strange to, when you discuss the work of the Constitutional Court, to refer to that as of the utmost political importance, but that is in fact what it is. Especially the apex courts, and which include, in this particular case, the Constitutional Court, are in fact crucial political role players. And what we have noticed in the past couple of years, perhaps more than a decade already, is that the Constitutional Court is in fact discharging a role as a crucial political role player. For that reason, this discussion is really critical. Let me secondly express my gratitude, ladies and gentlemen, for Mr. John Kane Berman's discussion. I had the privilege of having gone through the document over the past couple of days. Let me also say on a personal note, there are a small number of people who are really, to my mind, qualify as excellent political analysts in this country. There are, in fact, not many, but there are a few. And among them count people who come from among the ranks of the Institute of Race Relations. The names that announce themselves in this regard include the name of John Kane Berman, Anthea Jeffries, which is also here today, and then obviously also Frans Cronje. So thank you to them. I'm going to say a few things about a couple of cases. Obviously, I'm not going to cover all these cases. That has been done in a thorough way. There's no reason to deal with them any further. I'll make some side notes, especially on the last case, the language case of the Free State University case. I'll make some observations of what I call transformationism, not transformation, because what we have here is a full-scale ideology. It's a full-scale far leftist ideology which goes by the name of transformationism. My preference is to include the ISM, transformationism, in order to lay emphasis on the truth that we are in fact here confronted with a full-scale ideology. I will also say something about the practice of interpretation, because I think there are some misconceptions of what is in fact happening when a court interprets. I'll also say one or two things about judicial appointments, because that fits into the general discussion on the court's roles. And in conclusion, I'll make a few concluding remarks. Ladies and gentlemen, in the process, I might say things that might be derogatory to the previous Chief Justice Mogoeng. This, however, emanates from his ipsissima verba, from what he has said. It's evidence that he has provided against himself. So you will please accept my apology for just presenting the evidence that he has presented against himself. Ladies and gentlemen, the main ideology, the dominant ideology present in South Africa is that of transformationism. In a nutshell, that is the drive for an egalitarian society based on a socialist economy, true full-fledged social economy, also based on monoculture, a single culture for the entire state, and thirdly, upon a particular grand narrative, stated in another way, the way in which the history of the world, the history of Africa, and also the history of South Africa is construed. Namely, that at the beginning, sometime, there was some stage, some phase of paradise, of complete equality, which was then fundamentally disrupted by some sinful events. In this particular case, that of colonialism, rounded off by apartheid. Fortunately, followed up by a moment of redemption, which is either a revolution or, more specifically, in the case of South Africa, a peaceful transition, but also a peaceful transition of a revolutionary kind, which one might associate with the postscript of the interim constitution of 1993, and then the dawn of a new society, the transformed society, which is then marked by equality and monoculture. The Constitutional Court is, in fact, an interpreter and an applier and an enforcer of this transformationist ideology. Immediately, ladies and gentlemen, you might question what I'm saying, because there are numerous cases, and I mean numerous cases, in which the courts, including the Constitutional Court, gave good judgments. Ladies and gentlemen, whenever you are dealing with a case that does not involve some aspect of transformationism, the expectation is that you could get a good judgment in which the best interpretation of the applicable positive law would be applied. As a matter of fact, there are also cases of a political nature, however, not involving any aspect of transformationism, in which the courts gave good judgments. I'd mention just two. I can mention a couple of them. But firstly, the Condylar Judgment, which all of us know quite well. That is a judgment in which the Constitutional Court basically ruled against the ANC caucus in the National Assembly and also against Mr. Zuma himself concerning the way in which the ANC caucus conducted themselves vis-à-vis the report of the public protector, basically reviewing it and actually setting it aside. The second case, a very important case, is the SASSA case, in which the Department of Social Affairs and the relevant minister, Dlamini, really botched up, as a matter of fact, to such an extent that the paying out of grants to 17 million people were in fact at stake. That is back in 2017. None of these two cases, ladies and gentlemen, however, involve any aspect of transformationism. True, the SASSA judgment did clearly cause a tremendous amount of political embarrassment to government. But the very rights that were at stake, or that formed the background of the payment of social grants, were rights emanating from Section 26 and 27 of the Constitution, which in themselves represent the embodiment of ANC ideology, namely to create an equalized society. It was precisely the ANC back during the constitutional negotiations in the 1990s who strongly pressed for these rights to be acknowledged, in contradistinction to opponents of the ANC at that stage. So when the Constitutional Court gave judgments against Dlamini and against SASSA, it actually restored a hiccup within the broad ideological framework of the ANC. These judgments, ladies and gentlemen, stand into stark contrast with the judgment discussed by Mr. John Kane Berman. I'm not going to discuss these judgments. I'm going to add one, and then I want to say, make some extra notes about the last case, the University of the Free State case. Ladies and gentlemen, there's also another case, that's the Glenister case, that goes back to 2015. In that particular case, Mr. Glenister questioned the legitimacy, the constitutional legitimacy of the legislation that provided for the replacement of the so-called scorpions with the hawks, arguing that, in a nutshell, the hawks being placed under the supervision of the police, that would be unconstitutional. Why? Because, as was argued, the police is a fundamentally corrupt institution. It was put very bluntly, a corrupt institution. under the supervision of the national executive, which in itself was corrupt, because it was part and parcel of the ANC leadership, which broadly speaking, as Mr. Glenister argued, was in fact fundamentally corrupt. The important thing was this, that he sought to present expert evidence amounting to something like 1,000 pages. The state in defense argued that this evidence was irrelevant, scandalous, and vexatious, and argued that it should be struck out precisely for that. In other words, the state took their case against the evidence being presented as admissible evidence purely on law of evidence grounds. The Constitutional Court strongly agreed with the state, arguing that this was in fact scandalous and vexatious for Glenister and for his counsel to portray South Africa in that particular way. There was, however, a minority judgment given by Vroneman and Cameron, in which it was said, look, it is indeed a scandal to South Africa to think that the things that are being said in that evidence could be said, that South Africa could have deteriorated to a situation where evidence of this case is presented before court. This is indeed appalling. But the fact that the evidence is appalling does not mean that it cannot be adduced, does not mean that it is of necessity inadmissible evidence. That, however, unfortunately, was only the minority judgment. Ladies and gentlemen, I submit that what was at stake in this particular case was no law of evidence principle. What at stake here was a principle of transformationism, namely the grand narrative, namely of the redemption that has set in after the National Party came to, after the ANC came to power in 1993. This basic grand narrative was challenged. This was simply too much, obviously, for the state to stomach, and eventually it was simply too much for the majority of the Constitutional Court to stomach. Precisely for that reason, not for the reasons expressly stated, but for this actual reason, this evidence was regarded as inadmissible. Then, ladies and gentlemen, a few remarks about the question of, about the case of the Free State language case. Ladies and gentlemen, right at the beginning of the case, without any evidence having been adduced to that effect, Mogoeng already said, as I said, in the absence of any evidence that was adduced to that effect, found, and that was already quite early in the case, that the continuation of Afrikaans as a language of instruction at the University of the Free State would constitute racial segregation. Secondly, it would constitute unequal access to knowledge. I never knew Afrikaans was so wonderfully equipped with content that it provided better access to knowledge than English or any other language. Thirdly, it entrenched racial exclusivity, and fourthly, that it continue or leads to racial supremacy. Quite a startling statement to make, but that is what he said right at the beginning of his judgment. Also, fairly at the beginning of the judgment, paragraph 4, 5, he said, paragraph 7 of the judgment, which was something like 150 paragraphs eventually. Mogoeng said, on close analysis, Mogoeng decided in favor of the university very early in the 7th paragraph in his judgment when he described the decision to abolish Afrikaans, that's the decision by the Council of the University of the Free State, as a measure to promote the constitutionally inspired transformational agenda. Right. Apparently, and that's the important thing, apparently Mogoeng did not realize that that statement clearly betrays his and his supporters, the majority of the court's own prejudice, and more specifically their partiality, their ideological partiality in this particular case, which predetermined the outcome of the case. Ladies and gentlemen, this leads to the minority judgment by Vroneman, supported by 2 others. What basically happened in the minority judgment, and I just sum it up, the minority judgment boils down to actually to an impassioned criticism of the majority being partial instead of being impartial. There are at least 7 indications showing, clearly to my mind, proving the partiality of the approach that was adopted by the majority, for whom Mogoeng spoke. The interesting thing is also this, right at the beginning of the judgment, Mogoeng avowed his own impartiality, which is actually a very odd thing to do. There's no reason for a judge to define and to proclaim his own partiality. It's assumed. So why did he do so? Did he possibly suspect that there might be question marks being placed over his impartiality? Ladies and gentlemen, in the minority judgment, there are, as I've said, at least 7 indications of the partiality, more specifically the ideological partiality of the majority which determines the case. In the first place, the so-called historical context. Now, in all ideological slanting cases, the Constitutional Court nowadays begin with an historical context, even though judges are clearly not historians. And even though, for purposes of making a statement on anything on which you as a judge is not an expert, you need evidence. You cannot simply take judicial cognizance of that. As a matter of fact, in a previous judgment, in Daniels versus Kribante, it was a case judgment handed down last year. One of the judges in a minority judgment, that was Cameron, said, it was Cameron, yeah, that's right, said, look, please, colleagues, we should be reluctant, we should constrain ourselves when it comes to making statements about history, because after all, coming to think of it, we are in fact not experts in this case, on this question. So that was the first thing. The historical context was clearly skewed in the way it was sketched by Mogoeng and his supporters, simply placing overemphasis on one aspect and ignoring some other aspects. That was specifically pointed out by Vroneman and his supporters in the minority judgment. In the second place, it also ignored the uphill battle of Afrikaans as a university language itself, which is part of the historical context. In the third place, the majority actually made a misrepresentation of the so-called Gerwel Committee, who advised the then minister, that was back in 2002, of higher education on the question of Afrikaans at institutions of higher education, more specifically universities. In the Gerwel Committee's report, it was specifically recommended that some universities should take the responsibility for protecting and promoting Afrikaans. The majority, that is Mogoeng, did refer to the Gerwel Committee's report, but chose only to refer to those aspects that suits and promotes his argument, ignoring what I've just said, that there was also a specific subscription to the principle, the idea that some universities must specifically take responsible for Afrikaans. Fourthly, the majority also failed to give a proper, balanced reflection of the legal position, specifically ignoring Section 6.2 of the Constitution, which relates to the promotion of the indigenous languages, which includes Afrikaans. Fourthly, the majority also preferred not to refer to the relevant international law on this question, on minority rights, minority issues, minority claims, which would have been a body of arguments strongly supporting the case against the university and strongly supporting then obviously the case of AfriForum and Solidarity, the continuation of Afrikaans as a language of instruction at university. It's quite conspicuous that this was ignored because having ignored it, it provides further ostensible basis for giving judgment in the way in which the majority eventually gave judgment. In the sixth instance, a very strange, very odd thing happened, and that is that the majority simply accepted the allegations made by the university without going into the merits of it. In that sense, this wasn't a judgment, because you can only give judgment on the basis of facts that were tested, evidence that was presented before court, evidence that is properly weighed and properly criticized, and on the basis of which you reach a conclusion that these and these and these facts have been proven on a balance of probabilities and the others not. There was no exercise to that effect, nothing. Simply accepted the ipsissima verba, the allegations of the University Council. And then lastly, ladies and gentlemen, and these are all Vroneman's arguments, I'm basically summarizing what he has said. There was no allegation at all that if this so-called racial segregation took place, and if this so-called racial supremacy was the consequence of Afrikaans being retained as a language of instruction, there was no allegation or no evidence to the effect that that is actually the fault of the Afrikaans students, the fault of the students requiring of Afrikaans as a language of instruction. To the extent that these things did occur, and that is a question, as I've said, because there was no evidence on it, but to the extent that it might have occurred, there was no no indications that this was the fault of the Afrikaans students. On the contrary, if it was the fault of anybody, then it must be the university council, the university authorities themselves. Then they must be questioned for that. They must be faulted for that. Nothing of that. It was simply, the conclusion was simply, well, get rid of Afrikaans to that effect. Okay, ladies and gentlemen, where does this come from? Where does this transformationist form of interpretation come from? Is it a new thing? Perhaps also, sir, responding in part to the question that you've asked, is it a new thing? Is it something that has only that has come to the fore as in the Mogoeng court in the last 5-6 years? Or are we dealing here with something which is fairly well ingrained in the judicial convictions of the Constitutional Court? The answer, ladies and gentlemen, that this is in fact an old thing. Back in 1998, United States scholar on the left wing, no question about that, I can say that without any fear of contradiction. Carl Clare was in South Africa, also wrote an article, very romanticized articles, especially by left-slanting academics in South Africa and also by judges, in which he actually coined the idea of transformationism, what I call transformationism, what he called transformation. He was actually part of a small group of other academics that were also in South Africa from overseas, such as Drusilla Cornell, who hold the same, basically, transformationist views that I tried to sum up right at the beginning. Now, ladies and gentlemen, also, so this is the idea of a long-term project towards the achievement of an egalitarian society, socialist, classless society, based on monoculture, homogeneous culture. But also back in 2002 already, Mr. Justice Moseneke wrote an article that appeared in the Stellenbosch Law Journal, and Mr. Justice Lango was the Chief Justice, also in 2006 in the same journal. Together with that, there were articles by Albertijn and Goldblatt, two, if I may say, left-wing academics, and also by Professor Sandra Liebenberg of Stellenbosch University. Basically promoting the idea of transformationism and kind of packing out all the finer details of that. So the basis of this, the question might be asked: what is the constitutional basis for this? If we look for some constitutional provision that provides the basis for this, where might we be looking for that? Or if not a specific constitutional provision, is there possibly a specific dictum of the Constitutional Court that provide the basis for this whole idea of transformationism, substantive equality, and so on and so forth? Ladies and gentlemen, in the Constitution, in section 1, the foundational principles, there is the so-called, what the people that I've just mentioned make much of, the so-called activist formulation of the idea of equality. What is subscribed is not only the right to equality, but also the value of equality, but it is subscribed in activist terms. It is not equality as such that is subscribed to, but the achievement of equality. So there has to be a process underway in order to eventually achieve equality. The basis of this came from the judgment of Hugo versus President of the RSA. That's a 1995 judgment. In this case, Kriegler, believe it or not, said the following: the South African Constitution is primarily and emphatically an egalitarian constitution. The supreme laws of comparable constitutional states may underscore other principles and rights, but in the light of our particular history and vision for the future, a constitution was written with equality at its center. Equality is our constitution's focus and organizing principle. All the people that I've referred to now referred basically to that. What are the roles, ladies and gentlemen? What is the role of the courts, and specifically the Constitutional Court in that? All the people that I've just mentioned specifically made mention of the role and the responsibility of the courts, more particular also of the Constitutional Court. Moseneke stated, the judiciary, he concluded, is commanded to observe with unfailing fidelity the transformative mission of the Constitution. Sandra Liebenberg of Stellenbosch subscribes to, that's a very interesting term, subscribes to what she calls a dialogical conception of separation of powers, in terms of which there has to be close cooperation between all the branches of the state, specifically including the courts, to achieve the aims, the goals of transformationism. So there you have it, ladies and gentlemen. It's an old thing. It's ingrained in the thinking of the Constitutional Court, and what we have been witnessing in the past couple of years is simply this kind of convictions that are reaching some kind of zenith in the judgments of the Constitutional Court. Ladies and gentlemen, what happens when a court interprets? A court interprets, and every one of us interpret, according to our own pre-understanding of a document. We have certain pre-understandings. There are certain things that we expect the document to produce, certain things that we expect that a document must serve, specifically also a constitution. Some of these pre-understandings and these expectations that we cherish to find in the Constitution is obviously ideological. In terms of the views taken by all the people mentioned and that has been forthcoming in the cases that have been discussed, the Constitution is to achieve the aims and the goals of transformationism. Now, this is not necessarily correct. As a matter of fact, I think it's wrong. But where does it come from? Well, whenever one interprets, you interpret not as an individual, but you interpret as a member of an interpretive community, sharing particular views, sharing particular ideological proclivities, and you interpret in terms of that particular background. Now, the Constitutional Court also does that. By and large, the Constitutional Court, together with the rest of the dominant elite, interpret the Constitution also on account and inspired by their specific ideological expectations of the Constitution, namely to achieve transformationism. Most of us, perhaps all of us in this room, would interpret it, would be members of a different interpretive community or communities, and would interpret the Constitution differently. To that end, ladies and gentlemen, it is in fact correct to say that, strictly speaking, even though there is one single constitutional text, there are in fact as many constitutions as there are interpretive communities. At the moment, the interpretive community, and for the past couple of years, more than a decade and so, that dominant transformative community is in fact the community that interpret in terms of the in terms of transformative ideology. To that extent, all interpretive communities, including of the dominant interpretive community, the transformationist one would say, no, we do not interpret the Constitution incorrectly, neither do we lay any words in the mouth of the Constitution. The Constitution, in fact, says nothing. The Constitution only speaks when it is interpreted, and it only speaks when it's interpreted, it only speaks authoritatively when it's interpreted in the final analysis by the Constitutional Court. Now, ladies and gentlemen, when the Constitutional Court interprets in that way, it in fact exercises power. And the power that it exercises might be to the detriment of people who might argue that their rights are being infringed by the Constitutional Court. That instead of the Constitutional Court acting as a protector of rights and as an upholder and defender of constitutionalism, that the Constitutional Court, in fact, does exactly the opposite. They might say that the Constitutional Court exercises power and that the Constitutional Court does so illegitimately. Obviously, the majority of the Constitutional Court would say, no, we do exercise power, but we exercise power legitimately. Ladies and gentlemen, for a moment, let's go back to Max Weber. Max Weber, as all of you know, said, what is the state? The state, in the final analysis, is the embodiment of the monopoly of legitimate force, which in particular cases could also include violence. Now, I think what we must understand is the following. The legitimate wielders of force are not only the security agencies of the state, but also more subtly, the legislature, the executive, the state administration, all of which share in the monopoly through the specific kinds of force associated with each branch. Importantly, it also includes the highest courts, specifically the apex court, whose interpretation, in keeping with the ideological commitments of the dominant elite, of which they are an element, exert force in favor of the dominant elite and against its challenges. They also, in cooperation with other agencies of the state, take part in the monopoly of force. When they legitimately convict and punish, interdict and grant damages, and also, with dubious legitimacy, when they rule against the claims of those sectors in society outside the dominant elite, and in doing so violate their interest, to the extent that might be legitimacy in their actions, it is legitimate only in terms of the ideological commitments of the dominant elite as articulated in the legal terms used by the apex court. This is what happened in all the cases that we have discussed. It was the exercising of force by the courts in terms of their role as part and parcel of the monopoly of force, which, to my mind, has been exercised in such a way as to illegitimately infringe upon the legitimate claims and rights of the challenges, the ideological challenges of transformationism. I make a few last remarks, ladies and gentlemen, about judicial appointments. In 2013, and perhaps some of us would have forgotten about that, but it is something that we should again call into memory. There was a huge wrangle within the Judicial Service Commission. It was alleged that some judges, specifically white judges, with excellent, specifically liberal and human rights credentials, were not seriously considered for judicial appointments. They were subjected to grueling questioning by the Judicial Service Commission, in contrast to other candidates who really had plain sailing, jokes being exchanged between them and between the candidates and the Judicial Service Commission, and so on. Mr. Isaac Smits, a senior advocate who was a member of the Judicial Service Commission, said, well, the Judicial Service Commission should be honest towards white candidates, and should tell them, look, sorry, you should not any longer bother applying for judicial appointments because we're not going to consider you. And then, ladies and gentlemen, there was a huge fracas in the media also, and in that also participated Mr. Justice Mogoeng. And he said, and I quote, when it comes to judicial appointments, it is not all about merit. And there is no requirement that the best of the best should be appointed to the bench. So who must be appointed to the bench? Who must be appointed to the bench are those candidates, and this is no thumbs up. This is precisely what the Judicial Service Commission does. Whenever it questions candidates for judicial appointment, they question them specifically on their so-called transformationist credentials, the extent to which they do or do not subscribe to the ideology of transformationism. The bottom line is that the way in which the Judicial Services Commission has been going about, under the chairmanship of the Chief Justice, various Chief Justices already, and the way in which the courts have been going about, specifically the Constitutional Court, in dealing with cases in which, according to their interpretation, one or more aspect of transformationism is challenged, they are in fact, they do in fact show their prejudice. The evidence to that is overwhelming as far as I'm concerned, and they show their clear impartiality. This is clear not only from the judgments being discussed here today, and we can add a couple of others, but also from the extrajudicial statements made in speeches, made in articles, and so on and so forth. I've referred to some of them. Ladies and gentlemen, in the final analysis, and I conclude with that, the question arises whether there's not possibly some fault in the way in which we look upon the idea of separation of powers and judicial independence, and more specifically, judicial impartiality. I think the time has come, if one considers the South African situation, but also if one considers the situation, for example, in the United States, and also some other jurisdictions where very often than not there are disputes about judicial appointments. This should show us, ladies and gentlemen, that we should reconsider the whole question of separation of powers and impartiality of the judiciary. Ladies and gentlemen, to be presumptuous, at the risk of being presumptuous, I wrote quite some stuff on this, and may I quote from you just for time's sake, and then I conclude by saying the following. What it brings to light, and this is true not only for South Africa, but I think also in some other countries, some other jurisdictions where you have deep cleavages as far as ideology is concerned. What it brings to light is the reality of the actual unity of the three so-called separate powers, rather than their constitutional doctrine proclaimed separation. The three powers are separated in terms of institutions, personnel, and functions, but usually firmly unified in one single power elite. Integral segments of one and the same dominant political leadership, informed by the same ideological assumptions, committed to achieving the same goals, yet organized on the basis of a definition of labor performed in separate branches. The courts here in South Africa, but arguably also ordinarily, play their part as one of the branches, yet are distinctly the weakest within the overreaching dominant elite. They do so in close conformity with the rest of the elite, and they are incapable of doing, when it comes to ideological matters, incapable of doing anything outside the consensus which is prevalent within the dominant political elite. Ladies and gentlemen, to that extent, and I know this is not soothing, I know this is upsetting, but I think we should allow ourselves to be confronted by the upsetting facts so as to enable to do something about that. We should ask the question, is there really something like a supreme constitution? The question is that this should be challenged. This should be questioned, because in the final analysis, the Constitution is only that which the apex court, the Constitutional Court in this case, proclaim it is. Is there something really like separation of powers and impartiality of the judiciary to the extent that we might believe in that? I think the answer is no. We always, very often, proclaimed in almost religious-like terms that rights are guaranteed, that rights are entrenched, that rights are enshrined. If the rights only get meaning once a highest court say what it means, and if that right in that interpretation eventually brings to light that you do not have the right, then it appears that the rights that we might think that are entrenched are in fact, in the final analysis, not entrenched at all. This means, in the final analysis, and I leave it at that we are confronted with an unsettling situation. At the same time, fortunately, there are many other strategies of constitutionalism which must all contribute towards a proper division of power, dispersion of power, and that should not only include organs of state and the courts, but that should specifically also include a very activist civil society anchored in the variety of communities within the polity. Thank you.